Good morning, and thank you for the opportunity to participate on this panel. Our team at the Surface Rights Board is very committed to responding to inquiries about our processes and to make it as effective and user-friendly process that we can. The Surface Rights Board assists landowners and operators to resolve disputes related to surface access and compensation for development of power transmission lines as well as oil and gas development. We have 4 key application types that we deal with. Firstly, it's the applications for right of entry and then the subsequent determination of compensation for that entry. So this is when there is entry required after there's been a license by the Alberta Utilities Commission or the Alberta Energy Regulator. The parties are unable to agree on the access or compensation to the application to the Surface Rights Board. Once our board determines that all the requirements of making an application have been complied with, the board will grant right of entry, and then there will be the determination of compensation for that entry in accordance with the Surface Rights Act. We also have key applications involving review of annual compensation under a surface lease or a board order. So when there is a disagreement about what the 5-year review of compensation should be, again, application may be made to the Surface Rights Board. Thirdly, we have damages applications. And so when there's a dispute again between operators and landowners for off-site damages, application may be made to the board. And if parties are unable to agree, our board may set the compensation for the damages. Finally, we have applications for recovery of rentals under a surface lease or a board order. And when the due date for payment of that annual compensation has passed and the amounts owing are outstanding, the party entitled to receive the compensation may apply to our board. And when all the legislative requirements are met, our board may direct payment on behalf of the operator, and then the amount that has been paid becomes a debt owing to the ministry from the operator. Our application volumes are quite down this year, and I guess in many ways that's a testimony to how well the parties are doing in terms of resolving disputes between themselves. And it may be a testimony to the focus of the program at the Surface Rights Board, and that is that we are directed to focus on assisting the parties to resolve their disputes through facilitated discussions and by providing resources to the parties either by individual appointment or through our website. And by providing the information and by facilitating respectful and informed conversations, rather than having matters go to the board through determination in the quasi-judicial process, the parties are more likely to reach an agreement. We have a very strong team, very committed to our stakeholders, a team of about 25 staff and 15 board members. Our staff are all designated to a specific file. They become very knowledgeable about that file, and they are a single point of contact for our stakeholders to make sure that there's consistent oversight and consistent information being provided to anybody that's inquiring on the file. I guess, as I said, the applications are down. We're more or less looking at something less than 1,000 applications this year at the rate we're going right now, where in the past we've been more up at the 1,300 rate. And so, you know, we are pleased for that for our stakeholders because, again, as I indicated, there's seems to be success trickling down to future disputes by having worked through an interactive and respectful communication to resolve disputes in the previous years. So that's really all I'll say to you about the introduction. Thank you.
The Property Rights Advocate Office hears from a number of people throughout the year, sometimes through direct contact from landowners and also at various speaking engagements. Some landowners call us just for information about what their rights and remedies are in a given situation, whether that's oil and gas development or power line development, expropriation, things like that. And in that, there's a lot of overlap with Peter's office at the Farmers Advocate, because they will give out the same kinds of information we do, or maybe I should say we would give out the same kinds of information Peter's people does. Although we'd go a little bit broader, we also deal with small acreage owners and urban people as well. I also receive a surprising number of calls that involve landlord and tenant disputes and municipal land use issues. Now, those things aren't really within our jurisdiction, even though that they do relate to people's property and their rights of enjoyment. But even though it's not in our mandate, we still try to give them as much information as we can on whatever issue they're facing. When I talk to people, and more importantly, listen to them, I also try to identify problems in the property rights area and find ways to influence ways that property rights can be improved in Alberta. One of the ways that we try to influence policy is by making specific recommendations in my annual report. As the property rights advocate, I'm required by law to write an annual report which gets filed with the Speaker of the Legislative Assembly. It doesn't get worked through or vetted through the government department or Department of Justice, where administratively we're placed. It goes to the Speaker's office. The Speaker tables the report for consideration by members of the Legislative Assembly. I've prepared 2 annual reports so far, although the last one was filed with the Speaker in early June when the House was not sitting, so it hasn't been tabled yet, although it has been distributed electronically to all of the MLAs. In these 2 reports, I've talked about a number of property rights principles, tried to articulate what it means to have property rights, and I've also made a total of 6 recommendations. That includes, I've advised against privatizing the land titles registry. I've advised that some changes be made to the Surface Rights Act that would allow the rates for right of entry fees to be raised. And I've recommended an amendment to the Emergency Management Act. The office also tries to raise awareness and bring some influence to policy development by discussions directly with people in the public service. For example, I've made a presentation on my 2013 annual report to the Assistant Deputy Ministers pod that work in energy and natural resources. And staff from my office have participated in roundtable discussions about urban drilling. It's been nearly 2 years since my appointment, and in that time I believe that I and my staff have established this office as an impartial information resource, but also as a nonpartisan public voice for landowner concerns, for example, through the annual report recommendations and in the outreach to the public service. Although I do not represent individual people on their files, I don't go to court with them, for example, I do engage in issues advocacy, raising concerns and solutions, and in that law reform type of function, whether it's through the annual report or public service engagement, I think that's where our office can be the most useful in the long run. So thank you.
Everyone can hear me? I'm starting to hear some feedback, yeah. So thanks for the opportunity to represent and speak on behalf of the Alberta Energy Regulator. So our mandate, is it up on the screen? Not quite yet. There it is. So Alberta Energy Regulator came into existence last year in June 2013, and this is the mandate that we've been given as a new organization. So ensuring the safe, efficient, orderly, and environmentally responsible development of our hydrocarbon resources, essential and over the entire life cycle of energy development. So essentially, what it is if you look into our context of standing up the Alberta Energy Regulator, 7-8 years ago, we had a competitiveness review within the Alberta government. There was a sort of this economic downturn. Oil prices were going down. You might remember that time. But some of the recommendations that came out of that were how do we increase the efficiency of our energy development and the regulations around the energy development. So essentially, Alberta Energy Regulator does regulate the upstream activities and development of oil, gas, coal and oil sand. So we talked a little bit about coal this morning, so that was great. It's a fulsome regulatory mandate, and it is from the entire life cycle. So for when you think of the Alberta Energy Regulator, 2013, the Energy Resources Conservation Board was actually stood down at that time, and the Energy Regulator took on those responsibilities under those the energy enactments or energy legislation, such as Oil and Gas Conservation Act, Pipelines Act, and et cetera. But to be able to achieve that mandate of the full life cycle of regulation over the entire life cycle, there's been an expanded mandate from what the Energy Resources Conservation Board had. So December of last year, Public Lands Act authorizations or responsibilities for energy development came to the AER. In addition, there was Mines and Minerals Act, Section 8, which is essentially your geophysical or your seismic activity, so going to that front end, coming under the auspices of the single regulator for development in the province. Interestingly, also last December, we did have the private service agreements registry. It became available to Albertans, so some of the agreements between landowners and industry on their specific properties. We have that opportunity for registries right now, and then the AER as a regulator can become involved. This year, 2014, responsibilities under the Water Act and APIA, so the Environmental Protection and Enhancement Act, came over around the 1st of April. So last night we heard about Water Act and some of the responsibilities there, and so how are we involved now with the authorizations and approvals under Water Act, as well as the PIA. And then just most recently, October 1st, the responsibilities for environmental impact assessments for those energy development activities have come to AER. So we are looking now at a full cycle regulatory body, so right from exploration with seismic all the way to reclamation and remediation within under the PIA legislation. More specifically to how that is happening, I'm not going to go through all of the regulations or legislations because we would be here for a really long time. But to summarize, I think where we've been at as AER in the last 18 months is we've used the term lift and shift. So processes that you're familiar with in the past decade or so with all of those legislations actually have come to the AER. So any of the processes under a public lands authorization, for example, have come to the energy regulator from ESRD. There's been some tweaks, and hopefully it's moving towards that improved efficiency and effectiveness of energy regulation within the province. So Water Act, APIA, so even things such as how we are open to hearing from Albertans. So statements of concern, of course, were part of the regulatory processes in this province in the past. You would have been familiar with them under APIA or Water Act. So our legislation, the Responsible Energy Development Act, actually brought all of those processes together, and again, improvement. But where are we headed? I can promise you that there's going to be more change. We've done the lift and shift. We have the responsibilities within the energy regulator, and now we're going to turn our focus to how do we become more effective and more efficient with regulating these industries in the province. So as Bob had referred to yesterday, we have a new strategic plan. We're looking at how do we measure our successes. This is where we want to work with Albertans. We want to work with synergy groups. What does efficiency, what does the effectiveness and improvement look like? And I think that's probably a good snapshot of where we're at. I could go on for a long time.
Thanks. I'll see if I can sit here. It sounds a little echoey to me, though, with these. Is it okay out there? All right. Farmers Advocate Office, Frankly, I wanted to start by saying I'm surprised that you're even letting us up here. That talk by Jason was so cool. I thought that you would want to have him continue on, and I think I want to go to Calgary and take his course. I mean, that was very impressive. Farmers Advocate Office, as you may know, started in 1973. An order in council basically brought forward by then Agriculture Minister Hugh Horner and supported by Premier Lougheed said, gee, the oil and gas industry is starting to really expand in Alberta. Farmers and ranchers and landowners were, for the first time, running into situations where they were being approached by oil and gas companies, seismic companies, for access to their land. Farmers and ranchers at that time really had no experience in dealing with that issue. Our mandate, basically, we have two jobs. In the micro or individual file sense, our team helps farmers and ranchers deal with farm and ranch related issues. Very little of what we do these days relates to farmer versus farmer type of disputes. Most of what we are involved in these days relates to oil and gas related information and advocacy. And we're seeing a lot of times where farmers and ranchers are running into government and quasi-government organizations and rules and regulations, and we help them navigate the system. So we work on individual files. By show of hands, how many landowners in the room today? If you own property, so if you keep your hands up, how many of you are related to someone who owns farmland or ranch land? And how many of you have eaten in the past year? So we don't deal with acreage owners. We don't deal with calls that come in from people who live in the city unless they also own some farmland. So I think Dell might have owned land as far back in the 70s, and you know, the issues that come up for farmers and ranchers that we tend to deal with on the synergy side of things are what I would call sort of rarely repetitive issues. So a farmer and rancher deals every year with crop issues, planting issues, equipment issues. Every once in a while, there'll be someone that comes to them with a new proposition for development. Farmers and ranchers generally aren't experts in that area. They often come to us for advice. What are the rules? Where do I start? Because if anything is frustrating for all of us, it's getting a bit of a runaround as to where to go. So our job is basically to work with farmers and ranchers to navigate through the system. We do that on an individual basis. We get somewhere between 1,800 and 2,600 calls a year, depending on how you measure it. 1,600 of those can come up on farming, ranching, and oil and gas related issues. So it's a big part of what we do. From a macro perspective, we also work to try to improve the systems. One of the things that when I practiced law, I learned is that procedure is vital. It used to be said that procedure is the last refuge of small minds, that you can sort of use the procedure and you're not looking at the big perspective. But in my view and in my experience, procedure is vital to protecting and supporting the interests of farmers and ranchers. One example would be the issue of notice. We talked a bit about this last year. If notice of a proposed activity is given, that's in theory should be sufficient to let people deal with the system. In reality, the procedure of the notice is vital. The notice has to be sufficient in time, so a farmer or rancher can have time to learn about what's going on, engage assistance as necessary, and work on it. It has to be sufficient in scope. Who is affected? How are they affected? Who gets notice of it? If you don't know about something, you don't have a chance to learn about it and get a response in early enough. And it has to be sufficient in manner. We believe that one of the important issues about procedure is making sure that there's actual notice. Posting it somewhere may not be sufficient. How do you get actual notice? So from a macro perspective, my job is to try to work with our minister and the government to make sure that the procedures around all of what we're doing actually work and are fair to the landowners, because none of the oil and gas activity that goes on in the province goes on outside of the province. It's all on land, and all of the white land is developed. It's basically most of the oil and gas activity is on the white land, not the green lands, and it is owned or operated by farmers and ranchers, and we help them deal with the scary, constantly changing, frustrating world of how do I actually deal with oil and gas activity, and what do I do when there's a problem. So part of what we do is we make sure that we have relationships with the rest of these guys and work to make sure the procedure is constantly improved and that the system is as fair as possible so that farmers and ranchers at least know what the heck is going on, when they can do something, where they should go, and how they can appeal. So our job is basically to do two things: help farmers and ranchers deal with their individual files and work to improve the system. Thanks.
And Peter just touched on something about working together, and we had an interesting result of our first conversation as a panel and getting these four speakers talking to each other. And I'm going to let Peter tell about a new initiative that they've come up with.
Sure, and I first want to mention that this panel was the vision of Gary Redmond. And Gary, when I was on the Synergy conference committee this year, had come up with the idea of a panel that would try to answer the question, who are you going to call? So Gary, thank you very much for putting us together. What we recognized pretty early on when we met was that we can improve in a bunch of areas in terms of working together. It does seem that there's some opportunities for us to work better, and after our first planning meeting, we actually went away from an organized meeting with Synergy and through GAY and had our own meetings, and we've come up with a plan that we're going to do a better job of sharing information among our different organizations. So right now, for example, our office does not provide information to Jill at the Surface Rights Board as to how many calls we're getting that relate specifically to surface rights issues and how that would break down in terms of aggregates. People are unhappy with the money they're getting. Okay. People are unhappy with the process at the Surface Rights Board. Jill doesn't track information and send it to us as to how many referrals they're sending out to other organizations. How many people call the Surface Rights Board but really are sent on from them to either the regulator, to Lee's office, the Property Rights Advocate office, or our office. So because of the fact that we are working together to put this panel together, a result from Synergy has been that we're actually going to do a better job sharing information so that we're able to get the gaps that we identify. You know, gee, 800 people are calling every year to the Surface Rights Board when really they should be calling the regulator, or they should be calling our office. How do we do a better job not wasting their time, diverting them early on? So an outcome, and frankly from Synergy, is that every quarter we're going to be meeting and we're going to be working on sharing that information better so that you, your relatives, and your friends aren't going to be wasting any time going to the wrong spot. So that's an outcome that we see from Synergy. And Gary, this is your initiative, so thanks.
So I think a big round of applause to our panelists for already improving things. So we're going to do this panel a little bit differently than the other panels you've seen in this conference. On your table, you should have 4 pieces of colored paper. Okay? Did you find them? Some of the tables may not have them, but most of the tables should have 4 pieces of colored paper. They have on it the 4 organizations that our panelists are representing. What we want to do is we want to pose a scenario, and I want you to tell me who you're going to call. So by show of the colored pieces of paper, tell me who we should be calling in this particular situation. And our talented facilitators have prizes if you get it right. So I'm going to read the scenarios, and if you feel so inclined, there are blank white cards on your table. Write your own scenario and hold it up. One of the facilitators will come and get it. So our first scenario: the county needs to widen some roads to handle the increased traffic resulting from resource development. They plan to expropriate some land. You live near one of the roads and want to know your rights. Who are you going to call? Okay.
I don't know what the colors are, so.
That's right.
Well, mostly blue.
How many of you said that it's the property rights advocate? Yay. Okay, those people with blue will get some Smarties because they're the smart tables this morning. Lee, do you want to expand on this a little bit?
Well, just briefly, I mean, the answer is partly right, because we can give the information, that's easy enough, but as I had mentioned, that assuming you have more land than an acreage owner, Peter's office could also handle that as well.
But expropriation issues do fall under the property rights. Is that correct?
Yeah, it does, for
great.
sure. I'm just saying that in terms of the farming and ranching interests, that's where the overlap comes into play, is the information side.
Perfect. So the second correct answer would have been farmers advocate. Okay. No, sorry. Okay, the next one. Your company wants to drill some development wells. You've been working with the nearby landowners to identify issues and find solutions. You have letters of non-objection from all but one landowner. You have met a number of times with this landowner but can't seem to resolve the issue. Who are you going to call? Well, it doesn't matter what the issue is. How many said the Alberta Energy Regulator? Yay, the pink table. Rhonda, do you want to explain why that's the correct answer?
So as a part of the Alberta Energy Regulator, we do have an alternate dispute resolution team, so they could become involved in helping maneuver through some of those issues. Our community relations advisors also will help with that literacy, the education and understanding. So one of the pieces that I didn't speak to with the new organizational structure is the focus on relationships within the Alberta Energy Regulator. We have our own division, the stakeholder and government relations. So it's important for us to be moving forward as an organization and how we work with those relationships. So we've got a number of support networks there.
Great. So the key to that one, and why I said it didn't matter what the issue was because if you're in a situation where you can't seem to come to resolution, the appropriate dispute resolution team within AER can be your resource. So, next scenario, Muffin Oil and Gas has the surface lease on your property. The lease is up for renewal soon. You have left numerous messages, but the company has not called you back. Who are you going to call? Oh, we're going to run out of Smarties way too quickly because what the answer is Surface Rights Board. The Greens have it, and I'm going to let Jill explain about lease renewals.
Thank you. I'll make sure you guys can hear me.
Okay.
Everybody can hear me?
Okay, there we go. So under the Surface Rights Act, the operator is required to give notice of the 5-year review. And once that notice is provided, there's a year where the operator and the landowner may negotiate the 5-year review. If at the end of that year, the operator and the landowner are unable to come to an agreement, application may be made to the Surface Rights Board. When the application is made, the first step of the process is a pre-hearing dispute resolution conference call where the operator and the landowner and a board member discuss how best to come to an effective resolution of the dispute about the 5-year review. You can talk about things such as what have you done to attempt to resolve, what have you solved, what remains outstanding. Do you want to go through to a mediation where you actually commit to working through the dispute through facilitated mediation, or would you like to go to a hearing? And if you decide that you need to go to a hearing, there can be discussion of, well, where should the hearing occur, what dates, what disclosures, who are the witnesses, how much time is required. One of the things that's important to remember is that if the operator fails to give the required notice as to the 5-year review, the landowner may in turn give the operator notice that they want to enter into those discussions.
Great, thanks very much. Okay, our next one. And you know, you should be able to tell by the names that these aren't real companies. Fly-by-night gas has been doing some work near your property. You are not sure exactly what their operations are involved, but you suspect it might be the cause of damage to your water well. Peter, do you want to talk about the water well program?
Sure. Excuse me. Sure. There are though no wrong answers to most of these questions. It's a question of where you start. So generally, we get calls from people who might be going to the Surface Rights Board, but need our help first to say, what do I need to know? What seems to work? What doesn't? How do I get information? How do I price things? So in a lot of cases, I think most farmers and ranchers would be approaching a whole bunch of sources to gather information, get advice, and then work towards it. No good going to a mediation session if you aren't armed with sufficient facts and knowledge. On the water well issue, again, you probably could contact the regulator, because it may be that that there's a breach of a condition, and so the regulator may help out. If you did call our office, we would help you do a few things, get your facts organized, get the information. We would make contact on your behalf with the trucking company, the operator. We would help you get the facts organized and then help you decide how best to approach it. Are you best off to go to the regulator and have a condition enforced? Are you best off to perhaps go another route? So part of it would depend on what's happened to you. If at the end of the day, on my farm, my well is damaged, I have to drill a new well, and I can't work out an arrangement with the party, the oil company, or the whoever has caused the problem, the Farmers Advocate is responsible for administering a water well restoration fund, and I can get compensation as a landowner for my costs, and then some of those costs can be sought from the fund against the operator. So at the end of the day, if in the I need a well so my horses, my donkeys, my daughter's goats, and our cows have something to drink that's safe. I have to spend that money. How do I get reimbursed? Well, if there's no easy way to get it from the operator, you can come to our office, make an application under the Water Well Restoration Fund, and you will get compensation if the evidence chain is good enough. One thing I did want to point out, though, is that we see so few of these applications now because the industry practice has become, for seismic operations, for example, there's water well testing on neighboring land before and after the seismic activity. So there's baseline information that's received. So we don't see a lot of it, and we hope not to, because part of what we're doing is we're educating the land agents and farmers and ranchers to make sure that they're insisting on some baseline testing and data first. But so we'll help you with information, and we will help you with some money, but I see some hands coming up.
Okay, we could take a quick question, and then we want to move on to a scenario. Do we have a mic available?
While we're waiting, maybe I'll just speak on for the AER and how we're involved. So again, like this is a process that we're working with Environment and Sustainable Resource Development. So the impacts to water and to the water well. So that some of that evidence collection, that investigation would also occur through AER.
Okay, my question, I guess, would be around enforcing the energy company to restore or replace or do whatever work they had to do to fix that water well. Like, would the AER not be responsible for that enforcement piece with the energy company?
I'll answer that first of all, and the short answer is it depends. So it depends on whether there's conditions on the license that directly relate to, or the agreement that directly relate to it. As a landowner, a farmer and rancher, you can now register your agreements, and the AER can enforce those agreements. It's still a bit of an open question, in my view, as to who enforces a problem solution. So I'm alleging that my water well is damaged by some sort of oil and gas activity. The AER may not be in a position to make a decision as to who's at fault. So the short answer is they may be able to enforce it if it's a term of a condition, and if as a farmer rancher I register my private agreement, I can then have that enforced. But I bet that very few agreements have specific wording relating to it. And so we'll help you navigate the system. The AER, appropriate dispute resolution process, will, and I think the vast majority of operators are going to come to the table, work on the problem, and come to a solution. When you fall outside of that box, and when the poltergeists are there, then you can call us.
I think they're ghosts. The Ghostbusters need to come, right? No.
Yeah.
I'm just going to ask so we hold questions until we get through the scenarios that the panel's ready to present, and then we're going to open things up. I have had a couple of new scenarios come from the floor. We're more than happy to address those as well. So the next one is that you and prehistoric pipelines can't come to terms on the right-of-way agreement for a pipeline. They're going to route across your property. You've been told the issue is going to the Surface Rights Board for a hearing. You've never had to go to any type of hearing, and you're very confused and concerned. Who are you going to call? Well, as Peter said, there's no wrong answer on this one, but it is perhaps Jill that you want to phone first at the Surface Rights Board.
Thank you. Yes, if there's an application for right of entry and you're concerned about what is the process, definitely call the Surface Rights Board. There is a specific staff member that's assigned to your file, and they'll provide you detailed information on the process and on the specific status of your file. If we're in the early days and the matter hasn't quite gone to the pre-hearing dispute resolution conference, it would be primarily a staff member that you'd be speaking to, providing you the information on the status of your file and information on process. We don't provide advocacy, simply information on process. If your matter has proceeded, the right of entry has been granted, and now we're working towards setting the compensation, then you would be finding out a lot of information about process through the pre-hearing conference that I previously discussed, where you have a board member very knowledgeable in surface rights that is talking to both parties about the dispute and about the process to either arrive at a decision on compensation through your facilitated discussion or having the matter go to a hearing before the board.
Great, thanks, Jill. So, lots of advice on surface rights hearings available from Jill's office. You have a surface lease agreement with Roughshod Resources for a new compressor station. When you negotiated the agreement earlier this year, note earlier this year, Roughshod was asked to put a fence around the facility. The facility is up and running, but there is no fence. Who are you going to call? How many are saying Alberta Energy Regulator? Okay. Rhonda, do you want to tell us about this new program?
So as I had alerted to before, so we do have the private service agreement registry that is available. So as Peter said, and with most of these, it depends. If this agreement has been registered, and then the regulator can step in and work with that agreement to ensure that those all those terms and conditions have been adhered to. We're still waiting for our first dispute on this type of file, but we're ready. And yeah, I was going to say, I'm thinking that by having this registry, we're also helping the system move to resolution.
Okay. Peter, did you want to add to that?
Sure. Just a couple of things that are surprising, I think, to most landowners. One is that the Surface Rights Board does not have the authority to enforce the terms of its own orders. So if you have a right of entry order that would have a condition of a fence, for example, and it wasn't being built, one would think that you could go back to the Surface Rights Board to enforce the order. And until the regulator and the private registry situation came in, your only remedy was to go to court to enforce the order. So we're hoping, and as Rhonda said, there haven't been any, frankly, there's been nothing registered yet because people are only going to register agreements in time to deal with the problem. But we're hoping now that it will save farmers and ranchers and landowners money, that you don't have to sue to get the fence built, you don't have to prove damages that way, that they will actually be able to go to the regulator, and the regulator will be able to enforce by a direct order to the operator, build the fence, and the remedies that the regulator have, they can levy penalties and fines, and they can do everything up to including revoking the license. So there's a big hammer that the regulator has now that can be used, and I'm hopeful that any of these things that would have to go to court before now will be dealt with through the regulator. Haven't seen one yet, but this would be an area where who are you going to call was a constant source of frustration. What do you mean the Surface Rights Board gave me conditions in my right of entry order and won't enforce them? The fix now is through the regulator, we hope.
Great, thanks very much, Peter.
And there's one brief point I would also make, and that is to the extent that the non-compliance with a condition results in a loss of compensation. The Surface Rights Board can make awards on compensation, whether it's for off-site damages or loss of use and adverse effect. So there is that component that can be addressed at the Surface Rights Board.
Great. Okay, now everybody's been so smart this morning that we've run out of Smarties, but if you still want to play along with your colored cards, you can do so. Another scenario, Unresponsive Oil is doing construction on a lease in preparation for some drilling. Their trucks drive up and down the road in front of your house constantly, tearing up the road and creating lots of dust. You've talked to the construction supervisor, but things have not improved. Who are you going to call?
Good answers.
Okay, there is no one correct answer, and I heard a voice out in the wilderness there saying the municipality. Maybe Rhonda, I'm going to hand this one over to you because we've talked about people in this room you could even call.
Absolutely. So I think it was in the Rational Middle session yesterday, Earl Graham actually had talked about county being involved with land use agreements and some of their responsibilities as a municipal government. But actually, I think this is also an opportunity for all of us to be involved. Synergy groups have an awesome opportunity to actually look at some of these complex issues where there isn't one specific regulator or person or organization that's responsible for an issue. So how do we work collaboratively together with municipalities, with industry, with those that are affected, and how do we work towards those collaborative solutions? So yeah, this one was, I don't know, was it a trick question or scenario? Okay, but again, it's like, how do we work together? I think we're seeing more and more like these complex and really tricky, wicked problems work best through innovation and collaboration. So,
Peter?
And one thing that we see is that the operator will often contract and subcontract a lot of this work out. And the problem is that agreements that may have been made with the operator tend to get diluted and not understood, and the subcontractor wasn't in the room. So many oil and gas operators, if you can get hold of a person in their operation, they will help you actually deal with the subcontractor, because frankly, the subcontractor's under time and money pressure, doesn't make a nickel talking to you as a landowner, so you need to get their employer or their, the person that's paying them on side to convince them. So that's what we often recommend. If you can't deal with the construction operator, get hold of the oil and gas company.
Great, thank you very much, Peter. We've had some awesome questions come in from the floor, or scenarios with who you're going to call at the bottom of them. So I'm going to read these out. I don't know the answer, so we're going to hope our panelists can come up with some answers. You are buying a new home in Calgary. How do you find out about how close you are to a well and about that well? Anybody from our panel want to weigh in on that? Rhonda?
Oh, I was going to say, we've got some pink coming up. So
Some people had it right. Perfect.
Right. And also the development, when you're buying a home or you're building a home, and some of that comes under municipality responsibilities as well. So I think it's information that's available through the Energy Regulator. Yesterday we were talking at one of the sessions again about abandoned wells and finding those locations of abandoned wells, which we do have on our abandoned well viewer on our website as well. So that information is available, likely through us, but it should also, I would suggest, be available through your municipality. So, and again, I think this is how AER is working on improving those relationships with their municipalities, and how do we work together for achieving our outcomes.
The abandoned well map is on your website, correct?
Yeah.
Yeah, okay. All right, anybody? Peter, yeah.
Well, you should talk to your lawyer as well. I practiced law for over 20 years, and one of the things that is not, I don't know if it's never done, but I have never seen it done, where as a lawyer on a real estate transaction, I'm searching the interactive site that will tell me where the closest oil and gas development is. And with the new setback requirements for urban wells, with municipalities expanding outside of their traditional borders into the counties, it's something that I think will need to be done. And in fact, what I will do is make a note right now, and I'll contact the Canadian Bar Association and the Alberta Bar Association to see if their real estate subsections can start adding that in, because my kids are probably never going to be able to afford a home, but if they could, and they bought one outside in the new Sherwood Park development, that would be something that they'd want to know. So I think that's a great question, and I'll tell you right now, I don't think it's asked. If ever, it's only if someone has seen it. So it's rarely done, but if you're going to buy a house outside of a municipality or anywhere there might be activity, it's something I would have your lawyer do. But I think that's a great question.
Gary?
Okay,
Sorry, through the AER info services, you can request a land information development package. And so you basically describe the area that you're interested in, and you can get all the wells, facilities, pipelines that are located on that, and it will also tell you the setbacks that are associated with that, so you make sure when you're planning any development on your land that you're doing that with the appropriate setbacks that are associated with the development. I believe a landowner can request it at no cost, but if you're doing it for profit, so you're going to do a subdivision or a land development, then there is a small fee associated with it. If it's a larger request, of course, there is a fee.
Thanks very much for adding that in. Okay, I'm going to just rephrase this one slightly. I have a concern that the oil and gas operator near my home is using potable water in their operations. Who do I call? Rhonda, they're saying it's you.
Yeah, it's me. I was going to say so again. So this is some of the responsibilities under the Water Act. So licenses that are required for energy development now are part of the authorization process. So that should be tracked. It should have been approved through AER. So and again, the compliance, the associated compliance would be with that as well. So the terms of those conditions and conditions of that license.
Okay, thanks, Rhonda. Another great question or scenario from the floor. An oil company wants to build a road to accommodate heavy oil trucks servicing 8 wells. The road will be on your neighbor's land and 200 meters from your home. Dust control will be non-existent because it will be on private land. Dust and noise will be a huge problem. Who are you going to call? I see some different ones in the audience and a suggestion the municipality maybe is one of them. What do our panelists say?
You're going to look at me again.
No, I'm kind of looking at Peter.
Sure.
Peter?
We do run into this question, and currently, the answer depends on at what stage you become aware of it. So, if from the question it sounds like you're aware of what's planned, and that if the license has not yet been granted by the regulator, and that's, I guess, the first thing. If you're noticing an ad in the paper, or you hear from your neighbor that they're in negotiations, right. If the license has not yet been granted by the regulator, you can call someone, call us, get some help, but you can file a statement of concern as a directly and adversely affected person. You may not get notice, depending on what the operator has done and the regulators required. But even if you have not received notice or service of notice of the actual proposed development, you can file a statement of concern as a directly and adversely affected person by the proposed activity, and then argue that the regulator should impose a condition on the operation of that road and the construction of that road to minimize dust or to deal with your concerns. I'm not sure how successful you'll be in that application.
And so those statements of concern are to be filed within the 30 days of application being received by the Alberta Energy Regulator. But again, I think this is where you work with your municipalities, because they are also doing those negotiations with the energy development. So they have their rights as well as and those responsibilities around road agreements. So there's avenues that you can follow for some of those, so for yourself personally, but then also as a community. How do you work as community going forward?
Great, and I have one more. A rancher's water well is adversely affected by development of an adjacent acreage subdivision. The acreage subdivision has 35 residents on 1/4 section, each with its own well. And the rancher thinks this has impacted his well. Who's he going to call?
Well,
Well, we'll turn this one over to Lee.
yeah, it seems that it's really when you get into the land use bylaws and development, and that's more for the county or MD to deal with. And I think certainly if we got a call, that would be our advice or suggestion, is that they approach the county and work through those kinds of development approval processes.
Okay. And Peter, you want to add to that?
Sure. A couple of things. If you were here last night and you heard David Percy and the rest of the panel talk, last year I was participating in David's water law class, and I helped teach it. So a farmer and a rancher, basically you have certain rights to a certain amount of water, number of cubic meters per year. Basically there's 6. The level is 6 unless you have applied for a historical license prior to, I think, about 2002 to say we've had other cattle. So again, the answer, it will depend on how much your water has been affected. So you may have a remedy even if the development permit's been sent out by the county. But this water licensing, there's a sort of an implied certain amount for household use, another 5 for farm and ranch basic operations, and other amounts. So if you have a historic license, that can't be interfered with. The practical remedies are pretty tough to come up with, though, and so what I would suggest is, if you're a farmer and rancher, call us, because that's something that we can help you start to work on. And currently there's no charge for what we do in terms of helping out, but it's I suspect that is going to be more and more of an issue. The South Saskatchewan River Basin has been fully allocated. We are not seeing yet the drop in aquifer levels that they are in the States, but I think that's going to become more and more of a live issue. But there's some water licensing rights that you have as a landowner that certainly you may be able to get some compensation or another well drilled or water delivered, but it's going to be a complicated and ugly mess, and you better call us sooner rather than later. And if that's a real question right now, come and talk to me.
Go talk to Peter. Okay, so if my talented facilitators in the audience have their microphones ready, I think we have, Paula's got a question here.
Yes, I just wanted to address this to the AER. You mentioned in a conversation in regards to a scenario about a fence around a well that you said if the agreement had been registered. Now, who's responsible to register the agreement in the first place, and exactly what did you mean by that point?
So it is the responsibility of the landowner to register that agreement. So, and part of when this registry came on last December, so it was only agreements going forward, so in 2014. So they're not retroactive land agreements or prior to 2014, that those agreements can be registered. So it's landowners' responsibility to do that registration, and it's at the timing of when going forward.
Do we need to clarify? Just hang on a second, Mike's coming to you.
And while the Mike's walking over, the good news piece is that, the landowner is the only one that can register it. The company can't.
Yeah.
And there is no limitation period. So if you don't register it immediately because you haven't had a problem, you can register it later on.
Yeah.
And then the board, the regulator would have the ability to enforce it at that point. So according to the current act and regulations, there is no penalty for not registering immediately. So that's the good news, is that you can wait till you have a problem and register it, because you can keep some of the other information privately. But it is important to recognize that that's only for new agreements, not a historic one. So if you did one in 2012, you are at a bit of a loss as to getting the board to enforce it. Now that doesn't mean, though, that you shouldn't or couldn't have the appropriate dispute resolution process engaged, and frankly, for the most part, that will work. So you're out of the enforcement arm for pre 2013, I guess. 14 agreements, but you still have the alternate or appropriate dispute resolution option.
Okay, so that, because I'm thinking in the past, like we haven't had any dealings lately, but in the past, from the experience, you usually get approached by a certain landman that comes to your place and wants to do, have an agreement come to if they want to come across your property or use your property. So in the past, I don't remember having to register anything as a landowner. That's why I was asking about that. But so this is just new as of 2013, is that what you were saying?
November
or 14? Oh,
So, sorry, November 2013.
Okay.
Agreements dated on or after.
Okay, and Dave has a question over there.
Yes, just a couple of quick points. First of all, on the road use, the municipal roads. The only one that has authority over that is the municipality. That's clearly defined in the Municipal Government Act. I know what the County of Grand Prairie does. When somebody moves in, we charge them $10,000 a mile. We do whatever you want, and if they wreck the road or cause inconvenience to the landowner, we stop the move, we make them repair. If they don't, we go repair. And we can also charge them for additional damages. So that's an issue with the landowner, has to go back to the council, ban the road or whatever. The second one was on well site dust and one thing another. Municipality has zero influence on that. Municipality can only dictate what happens to internal roads on private land if they issue development permit. we cannot do anything on the private property where the ER has issued a license. The issuer of the license has to put the conditions in. And, you know, all these conditions that, whether it's fence, maintenance, or cattle guards, whatever, when a license is applied for, this should be stipulated in the application license. I shouldn't have to go and file myself later down the road certain conditions because they weren't adhered to. So you guys have come a long ways. You're still leaving us sitting with a bubble of air and doing all our own work. Thanks.
Does anyone want to respond?
I agree. We need to improve our relationship and how we work together. Absolutely. So again, we've talked about that there's gray areas. How do we work together? And I think, yeah, that's a great example on how we make things clearer.
Do we have other? Oh, question over here.
On that example where you gave for a road use agreement, unless things have changed, if it's a sweet well, the landowner next door is never going to get a notification of it because your notification requirements are so small. So the first that landowner would ever know about that road going in beside them is when the cats are in there building it. So it's a little late then to file a statement of concern, so how would you deal with that then?
Yeah, I was going to say, so, and a lot of these specifics, and again, with the different agreements, again, I'm going to point to our working with synergy groups. So how do you find out about those proposed developments? So we do have like the notifications and applications on our website. So those are one avenue, but also how do we work together as a community for finding out those future plans? So again, I think there's, yeah. Sorry?
It's very nice, but my synergy group isn't meeting until next month and the cats are working today. And I was never notified. So my question is, how do I file a statement of concern if I have 30 days and the license has already been granted?
So there are avenues, and I was going to say, and I'm not familiar with all the specifics, maybe somebody with the AER can help me about, if it's past those 30 days of filing for a statement of concern, we do have avenues if you can identify how you've been directly and adversely affected.
Maybe
Anybody
we have
can
an
help me with
answer
that one?
back there. Okay.
Hi, I'll just add to that a little bit. After a company files their application, I'm right here. Hi. After a company files their application with the AER, it's registered real time on our website through a new tool called the Public Application Tool. And anybody can go in and see every application that's being filed with our organization. And then you have 30 days after you see that that application's been filed to submit that statement of concern. So you can proactively be checking your area. You can be checking a specific company's applications. You can just be checking every single application that's registered if you're that curious. And then you have 30 days from when you see that application to file that statement of concern against that project. So it does allow for the folks that aren't required to be notified to see that projects are being applied for in their area.
Okay. Maybe we could,
sir.
Yeah, maybe we could continue a discussion on that in just a minute. We have another question over here.
I'd like to add one little point to that there is still other avenues, and there's local synergy groups within your area that network and have those discussions with your oil and gas companies that talk on a very regular basis what their activity levels are and come and present on a, like within our group, we present on a monthly basis what wells are going to be drilled in the area. So I think you're missing the component that there's the opportunity to have that proactive dialogue and contact your local synergy groups if you have some concerns with regards to being an adjacent landowner and what options are available to you within the program that they have.
Okay, do we have any other questions for the panel? Carla's got one over there.
I've been hearing an awful lot about oil and gas, but nothing about the power sector. Do any of you deal with electricity issues in landowners?
Okay.
Hello, I am from the Surface Rights Board. When I started with the board in 2007, I don't believe we had any applications for right of entry dealing with power transmission lines. Now in 2013, about 80% of our applications for right of entry dealt with power transmission lines. So if there's a dispute between the landowner and the operator regarding access or compensation for a power transmission line, there is the right of entry process and the subsequent determination of compensation process through the Surface Rights Board. And I've often get phone calls as well from landowners that are concerned about the enforcement of conditions on right-of-ways dealing with power transmission lines. And I've been informed by the Alberta Utilities Commission that they now have an office that is dealing with disputes over the enforcement of conditions and on right-of-ways for power transmission lines. And I can give that information to Synergy and make it available.
Peter?
Thanks. And our office has received a number of calls, and we've handled a bunch of files on the power line issue. There were two types of files we dealt with. The first was landowners who were on one of the proposed lines saying, okay, they may be running this through my property or adjacent to me. How do I approach the Utilities Commission in terms of raising my objections as to siting and routing? So we provided information and support there, so you can call us. Again, that's at the pre-license stage, I'd call it. The Alberta Utilities Commission issues the license, approves the route. So it becomes a question of actually how can you get this route changed or diverted, and there's a bunch of steps that can be taken there. What we did a lot of times, if people were significantly affected, was we actually got them lined up with experienced legal counsel in the area, because it's not something that most of us are experts at, and we don't have an employee in our farming or ranching organization that's monitoring the applications or getting up to speed on AUC applications. So you often have to get professional help. You have to lawyer up on that. But at least you know when to do it and how. And then secondly, we get calls on questions of negotiations on compensation. I'm hearing my neighbors getting X, I'm only offered Y, that's not fair. So we provide some support, general information on how the rules work, and we listen to the frustrations of what are alleged to be side deals, but we again provide basically an understanding for people as to the rules, what can they negotiate, what should they consider, and provide them with some information. And in some cases, again, we provide them, there are actually land agents now that you can hire to represent your interest as a landowner directly, that don't act for both sides, that they will act on your side. In some cases that works. Other cases, you can hire someone to help you negotiate, and in many cases, while it's discretionary, the fees and costs associated with the experts' reports, the legal help, can be covered as part of your agreement. So we can certainly help you at our office negotiate that system and advocate with you. But a lot of times, you're best to hire competent help, and we can help you identify some of those as well.
In follow-up of Peter's comments, I think Peter's alluded to a really important point, and that is that the Surface Rights Board, we're a quasi-judicial body. The board must be independent and must appear to be independent. So you're always going to simply get information on process from the board so that we're not prejudicing our obligation to be neutral. And that is why if you call the Surface Rights Board, you'll get the information, how to deal with the issue, the advocacy component, that will always go to the farmer's advocate.
Okay, there's one at the back. We'll take that as our last question, and then it's time to wrap up.
Thank you. Caroline Colababa, Northern Sunrise County. I find it a little disturbing when you ask or say to the residents that they can go to this list and find all the companies that may be within their direction. I think a review of that should be taken place, and that the regulatory body that permits those should automatically do a circumference area around that well, or whatever the case is, and notify the landowners directly. I don't think it's appropriate that landowners should have to go and do whatever. So you might want to take that back and relook at it. Thank you.
Peter.
And one of the first things I did when Mike Percy took office as Chief of Staff to the Premier was I met with Mike on that specific point, the issue of a concern that we have heard generally from farmers and ranchers that the scope of notice is insufficient, and that with a change in management, there's an opportunity for that to be done. But in my view, what I've heard from farmers and ranchers is that they want the regulator to have more direction from the government, either in the legislation or in some sort of other piece of governing legislation that requires the notice provisions to be broader, more effective, more timely, because it is certainly possible to look online, but it's impractical for us to do it. And so it's a political issue. I guess that would be the summary. And I am pushing that piece of paper forward, but there's a million other political issues on the table. So it can't hurt for you to talk about this with your MLAs. It can't hurt for you to talk about this with the Premier's office, and it can't hurt for you to talk about this with the Minister of Energy's office and with the regulator itself. Noise does attract attention, and this is something, if it's important to you, you can't leave it alone, and it's not sufficient for me to represent that on your behalf, in my view. If we want this to change, the government needs to hear loud and clear how it can be improved. So not just a complaint, but what we've given them is some suggestions as to how it can be better, because frankly, they're not the complaints department, it's the government. So it's not enough to raise it today. It's what I'm saying, have your synergy group raise it, get it out there, and the more that we raise it, the more of a chance we can have of improving the system.
Okay, well, I want to thank our panelists. Rob's doing the final come up and say hi.
All right. Well, that was fantastic. Great, engaging discussion. A round of applause for everybody up here, please.